The issue we're going to explore today is the Trans Mountain Pipeline expansion, which is one of the most controversial regional development issue over in Canada's recent history over these years. So the question we are going to ask is when it comes to regional development on indigenous land, whether the indigenous group or the federal government have the power to make a final decision. So first of all, we're going to take a look at the overview of the pipeline expansion project. So the pipeline has been in use since 1953, and it has been one of the largest proposed fossil fuel infrastructure projects in Canada. The expansion project was proposed by Trudeau government in 2016. It is going to be built from Edmonton, Alberta to Burnaby, British Columbia, and that's going to run parallel to the existing one, which will increase the volume of the crude shipped from 300,000 barrels to 890 barrels per day. According to the Trudeau government, he believes responsible rail development can go hand in hand with environmental protection, and it believes that it is in the best interest of the nation to support the pipeline expansion project, as it is foreseen to provide significant growth for the Canadian economy. It will first open up new work opportunities from British Columbia to Newfoundland. It will also open up Asia as a major exporting market. As the political uncertainty has been going on with the current United States presidency, Prime Minister Justin Trudeau wants to diversify export market by turning focus to the east. It is also believed that building this pipeline expansion will generate an additional $73.5 billion in revenue. What's more, in terms of meeting Canada's climate change accord of the Paris Agreement, the federal government wants to bring Alberta into dialogue by agreeing on their need to build a new pipeline. The oil, gas, and mining industry, together at 17%, has accounted for the biggest slice of the economy in Alberta. Therefore, allowing the pipeline extension project will greatly benefit the provincial economy of Alberta. However, if we want to understand the controversy lies behind the issue, we have to first look through the historical context, which will dating back to the colonial time. Aboriginal people have long settled in North America, and they didn't believe that land should be owned by any individuals. Rather, they believed humans and other living beings belong to the land. There are many important documents outlining the Aboriginal rights, including the 1763 Royal Proclamation. It is recognized in the proclamation that Aboriginal title has existed and continues to exist, and that all land will be considered Aboriginal land until ceded by treaty. Aboriginal land can only be sold or ceded to the Crown, and now directly to the settlers. The proclamation also set a foundation for the process of establishing treaties, which involved the presence of both parties. From the 18th century to the early 20th century, Crown representatives and the leaders of the Aboriginal communities have signed treaties throughout most of Canada in an effort to resolve the issue of outstanding Aboriginal title. These treaties set out agreements as to the nature and limits of the Aboriginal rights and title. Crown representatives interpreted these treaties as a blanket extinguishment of Aboriginal title. However, many have argued that at this time, when the treaty was negotiated, Aboriginal signatories have no prior understanding of the treaty as limiting or extinguishing their rights. The Supreme Court will later confirm that treaty should be interpreted with its First Nations interests in mind. In the case of the extension of the pipeline, it passes through the Treaty 6 and the Treaty 8 lands. Furthermore, in the Constitution Act of 1982, Section 35 recognized and affirms Aboriginal rights but with no clear definition. Therefore, it has aroused a lot of controversy with the interpretation of the Constitution. Critics believe that it reinforces colonialism by recognizing Canadian law as supreme rather than a true nation-to-nation relationship. When the pipeline was first built in 1951, it was illegal at the time for indigenous people to politically organize or hire a lawyer to advocate on their behalf. This is also why at this time, when they are given the right to express their concern publicly, they want to fully utilize their opportunity. Over the years, as written in the Section 35 of the Constitution Act, the self-governance and the self-determination of indigenous people are granted as their basic rights. They can freely determine their economic, social, and cultural development, and they are also given indigenous sovereignty over their own land, which ensure that they have a stronger role in the decision-making process with effective participation. In the case of the land, many of the land passed through by the pipeline expansion are the lands of Aboriginal title. The right to control land conferred by Aboriginal title means that governments and others seeking to use their land must obtain the consent from the Aboriginal title holders. From the Supreme Court of Canada ruling in the case of Haida Nation in 2004, it also states that the Crown, acting honorably, cannot cavalierly run roughshod over Aboriginal interests where claims affecting these interests are being seriously pursued in the process of treaty negotiation and proof. One of the major controversies aroused in the indigenous community are of environmental concern. They believe that building this pipeline is a breach of commitment made in Paris Agreement by the Trudeau government. The Trudeau government pleads to forge ahead the expansion, and the Alberta Premier Rachel Notley has threatened to pull out of Canada Climate Plan if the expansion project was to be suspended. Indigenous people have long established a relationship to the land that they live in, and they see themselves as protectors rather than protesters. They are worried that building this pipeline will impact their traditional activities like fishing and hunting, and they are also worried about the potential spills into the Salish Sea. For example, in 1989, the oil tanker Exxon Valdez struck a reef in Alaska, releasing 4,400 tons of oil, which has become one of the most predominant oil spills in North American history. From the case, Canadian government has rewrote the rules to ensure that industry was always responsible for the cause. And the potential oil spill could devastate marine life, including salmon and endangered species of killer whales. Moreover, there are also concerns such as in the cultural aspect. To the indigenous people, the lands are of spiritual importance as it ensures their identity, sense of belonging, and spirituality. Such project development will not be in the favor of indigenous community, even have impact benefit in the agreement side, as the indigenous people are always put on the weaker side in terms of negotiation. Economically, colonialism also brings impacts, and the indigenous community have lost their voice of how to use their own resources. It is also concerned that building this pipeline will impede the process of reconciliation, as the indigenous people see this as a broken promise from the Trudeau government. Before, the Prime Minister Trudeau has campaigned on the promise of renewed relationship with First Nation, and in particular a relationship based on the respect for Aboriginal rights. However, he had not been able to live up his promise that he would respect the First Nation right to say no to development on their own lands. In regards to the principle governing its relationship with indigenous people, the Liberal Party itself has underlined the honor of the Crown as the key principle. However, it just fails to address the importance of bringing indigenous people into the dialogue of negotiating in the resource development. Moving on to the legal issues existing in this case. First of all, there has been lack of consult from the federal government, which is an infringement of the Section 35, as enough consultation has to be acquired from the indigenous group from prior to the government action, and it should never be just a mere distribution of information or taking notes about Aboriginal people's concerns. The Crown has real or constructed knowledge of the potential or actual existence of British title, and contemplate conduct it might adversely affect it. The Crown is obliged to consult with the group asserting a British title, and if appropriate, accommodate Aboriginal rights. And they're also required to take indigenous perspective into account and minimize or eliminate their impacts. Furthermore, the project's impact was not assessed on the basis of each indigenous group, but on impact in the project area as a whole. Among the 153 indigenous groups affected in this matter, only 43 have signed a benefits agreement with the company. Government need to acquire consent from all the other indigenous groups prior to moving on to having other actions done. Furthermore, there has also been lack of consent by the indigenous people. According to the United Nations Declaration of on indigenous people have the right to free, prior, and informed consent prior to any result development project. As written in Article 26, indigenous people have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. They also have the right to own, use, develop, and control the lands, territories, and resources that they possess by reason of traditional ownership or other traditional occupation or use, as well as those which they have otherwise acquired. States should give legal recognition and protection to those land, territories, and resources. Such recognition shall be conducted with due respect to the custom, tradition, and the land tenure system of the indigenous people concerned. If there are any ambiguity, they should always be ruled in favor of the Aboriginal party. Due to the many questions remained, the construction activities are suspended by the government as the Federal Court of Appeal has overturned the Trudeau's government approval of the contentious expansion. In their ruling, they believe that the consultation process was unacceptably flawed and fell short of the standard prescribed by the jurisprudence of the Supreme Court. However, the duty to consult does not have any legal certainty, and it is believed that it does not have legal power and the consent does not need to be anonymous. There is also an issue of lack of meaningful two-way dialogue flowing from the model partnership. Indigenous people should be provided with the opportunity to participate in all respects, both procedural and substantive, of a project or activity that may affect their rights. There is also a lack of possible accommodation. For example, there is no implementation of a detailed environmental impact assessment as outlined by the indigenous group. In this stage of negotiation, many questions have still remained unanswered, and the result development has become halted in the process.